Welcome to a Stepping Stones interview for Democracy 17.4. I'm Caroline Stevens, and today I'm interviewing Torquil Dick Erickson. Torquil is on Skype from Rome. He's going to be explaining the problems with the European arrest warrant for the British people. Welcome, Torquil. Over to you. Tell us about the European arrest warrant and why we should be so concerned.
Thank you, Caroline. Well, there are three main things about the European arrest warrant that people are not aware of in Britain. First, people do not realize, and when I say people, I mean not only ordinary people, I mean the legislators who pass the legislation and the legal profession itself. They do not realize how profoundly different the systems of criminal law used in Europe are from ours. Second point is, so far there have been a smallish number of innocent British victims of the European arrest warrant struck down on a random basis. Many people may have heard of the case of Andrew Symeou, and there have been several others. One was actually a British judge, but there have been a small number, and they have been struck down in criminal investigations on a random basis. The average Briton thinks, well, it is unlikely to happen to me, so I need not worry too much. I will show that, on the contrary, authorities holding the kind of power that they hold with the European arrest warrant constitute a threat to democracy itself. And thirdly, I will want to show that the European arrest warrant is repugnant to the British Constitution, and how, on this basis, it may actually be struck down in court. This should not exonerate MPs and the media from their duty to consider it and to try to get it removed from the statute book. Now, the main difference between, as regards the European arrest warrant, the people in Britain think that the system used in continental Europe is similar to ours. Actually, it is not. In Britain, when there is a crime, detectives investigate it. They form suspicions. They collect evidence. And when they have enough evidence to arrest a suspect and to show that there is a case to answer so that they can charge the suspect formally, then and only then do they effect an arrest. And within hours after the arrest, the suspect has to be produced in open court in front of a bench of magistrates. It used to be lay magistrates, although now they are being replaced by these district judges who are, well, that's another issue. And then they are charged, and if necessary, in open court, in a public hearing, within hours or at the most days. In the very extreme cases of terrorist cases, the maximum, absolute maximum, is 28 days now. And the evidence that has been collected must be shown in the court, in public, at that point, within hours of arrest. And then the court decides whether the evidence is sufficient to commit the person to trial, and he may be committed on remand, which means waiting for the trial in prison. But the evidence has been collected before the arrest. On the continent, they do it the other way round. In other words, first there is a crime, and then the authorities appear, and they formulate suspicions, and they arrest the suspect at the beginning as the first step. This very often happens. Not always, but often happens. They arrest the suspect at the beginning of the investigation as the first step. And then when the suspect is safely put away under lock and key, then they investigate and try to collect evidence against him. And this, of course, can take months, sometimes even years. And at the end of the day, when they have enough evidence, then the person is charged and committed to trial. They don't actually have a public appearance in court in many jurisdictions until the trial itself begins. But so this is why people like Andrew Symeou, who was arrested in Britain on a European arrest warrant issued by Greece, transported to Greece, and there he waited 11 months in a horrible prison before his first appearance in court. At that appearance, they hadn't been able to find convincing evidence that he was guilty of what he was of the crime that was attributed to him, and the case collapsed and it was dismissed. Now, of course, the British think in their naive goodwill, they think that this is due to sloppiness on the part of the continental authorities, when people spend such a long time in prison before a first appearance in court. But the point is, it's different. It's a different system. We have habeas corpus. In the Napoleonic inquisitorial systems, they don't, which are prevalent on the continent, they don't have habeas corpus. So that is the first point that people must understand, that the system in Europe is totally different from ours and does not have the same safeguards, for example, of habeas corpus. So the second point is that people think that this is only for criminal cases, and if they haven't been involved in anything, they're most unlikely to be subjected to this kind of problem. Well, the trouble is that with the continental Napoleonic inquisitorial method of criminal investigation, where the authorities do not have to show any evidence of guilt for a very long time while the suspect is in prison, this confers on the authorities de facto a huge arbitrary power to have anybody inconvenient taken out, put away in prison for months pending investigation. You see, they are under no obligation to show any evidence, so there need not actually be any evidence. And this is a dangerous, arbitrary power. And when they have the European public prosecutor up and running, and he's in there, they're building, they're doing it, they are definitely intending to do this as soon as they can, then he will be able to issue European arrest warrants against people in Britain. Not only at present that we're still in the European Union, but Mrs. May's government, and this is something that the media have not talked about, let alone commented on, Mrs. May's government wants to keep the European arrest warrant forever after our exit, within a new security treaty that she says she is unconditionally committed to stipulating with our European partners after Brexit. Well, if people in Britain can be subjected to a European arrest warrant issued by a European prosecutor who undoubtedly will be a creature of the Commission, and so at the behest of people who have said they want to punish us for Brexit, we will be still a vassal, and we will indeed be a vassal state, because if anybody in Britain can be arrested on no evidence and put away and transported to Europe and put away, this means, that we are entirely at their mercy. She has also said, Mrs. May also said, and this has not been commented on, but it's in Hansard, she said when she was Home Secretary in June 2012, that of course she would welcome and ask for special intervention units from the continent to come from our European allies to come into Britain to help solve public order problems. But she didn't realize this means, she didn't tell people this means the Euro Gendarmerie. And the Euro Gendarmerie, once they're in the country, will only take orders from Brussels. And they are lethally armed paramilitary police. So that is a very dangerous situation. And however, this is already, the European arrest warrant is already being used for for political purposes, because that is how the powers around the world, the state, you see, it's something else that British people have forgotten.
So basically, we're talking about a loss of sovereignty, aren't we?
Oh, absolutely, and
so
freedom.
When we voted to leave on the 23rd of June 2016, we actually said we wanted to take back control. And Mrs. May made comments earlier on this year to say that she was prepared to give up the European arrest warrant yet again to Brussels. And so part and parcel of that is going to be the Euro Gendarmerie. She didn't mention that, I don't think, in her speech.
No, she wouldn't have mentioned it. They're very careful not to mention it, but it is already existing in embryo form. There is they have 6 countries who are taking part. Britain is not part of it because we do not have a paramilitary riot police force centrally controlled. But they are 6 countries are taking part and are drilling and training side by side in a location in northern Italy.
Which are the 6 countries?
The 6 countries are Italy, Spain, Portugal, France, Holland, and now I think Poland, and possibly Romania. Maybe there are 7. More countries are joining as they go along. Candidate countries can also possibly join, so that we may even have Turkish.
And there's no accountability, is there, with the Euro Gendarmerie?
The Euro Gendarmerie are accountable to a thing called, to a committee of European ministers in Brussels, who are ministers who, in their countries, they control these police. You see, in Britain, our police are not centrally controlled. We have 43 local constabularies, and they once interviewed the Home Secretary, and he said he thought they were all independent. He thought they were all independent. In every continental country, it is the Minister of the Interior, the equivalent to the Home Secretary, who controls the police, who are national, and they're nationally recruited and nationally deployed. And they're a very different kettle of fish from our police, or at least what our police used to be. Because our police and our judiciary they've been trying to introduce changes which make it more similar to the continental system. But so far.
So basically the message to the members of Democracy 17-4 should be, this is an example of where we have capitulated to the European Union and there is no evidence of a Brexit in this department.
Absolutely not. Mrs. Rudd and Mrs. May have both said they definitely, I don't know about the new Javid chap, but I suspect he will be of the same opinion. They want to keep us in Europol as members of Europol, which we are members of, and in and under the European arrest warrant indefinitely. They think the European arrest warrant is wonderful, to such an extent that Barnier has even sort of teased us by saying, well, you won't be able to have the European arrest warrant if you don't give in on my matters. They think it's wonderful. The police thinks it's wonderful, but we shouldn't necessarily listen to what the police want, because if we always listened to what the police wanted in our political arrangements, we would have a police state.
Well, of course, before we went into the European arrest warrant system, we used to have agreements, didn't we, with other countries to extradition treaties.
Yes. Now, well, indeed. Before that, there was a system where the big problem with the European arrest warrant is that the British court, faced with a European arrest warrant, has to order the person named in the warrant to be trussed up and shipped over, no questions asked. They are not allowed to ask to see, let alone assess, any evidence against him. And what they don't realise, what the legislators who passed this legislation, and I'm being charitable, didn't realise, was that sometimes there is no evidence at all, because on the continent they don't need evidence to arrest somebody. It is simply the judge on his. It's simply a judicial authority, which is a prosecutor, by the way, as Julian Assange discovered, as his lawyer found out, who is a judicial authority over there, but not in Britain. There are parties to the case, but they can just issue a warrant without needing to produce any evidence. And the fact is that they don't have habeas corpus, so the suspect, the prisoner, has no right to appear in a public hearing within hours of arrest and to demand that the authorities who have arrested him produce the evidence of a prima facie case to answer on which they arrested him. This is the big difference.
So you could have an example I could go to the continent, I could hire a car, I could be accused of going through a red light, already arriving back in this country. They could actually produce papers to a local court, and request my presence back on the continent. Is that true?
You don't have to go to the continent at all, actually. In fact, there was a case of a man called Edmond Arapi who had never been to Genoa, and he was suspected by the authorities in Italy of having murdered a man in Genoa, and they issued a European arrest warrant. And luckily, he had documentary evidence to show that on the date when this murder occurred, he was in Britain at the time, working at his job. And so they issued this warrant for his arrest, and the British court, as a rule, is not... in the end, the Brits managed to persuade the Italians to withdraw the warrant. But if that hadn't happened, the British court would simply have had to accept the warrant, have the man have you trussed up and shipped over. And then you would find yourself sitting in a French jail or wherever the country the arrest warrant came from for months while they tried to sort out your case and tried to build a case against you. Of course, in Italian law schools, they teach that confession is the queen of evidence. They hope, of course, although they don't say this openly, but they hope, in effect, that you will confess under the harsh conditions of prison, under the harsh stress of prison conditions. There have been TV programs recently in Italy of thousands of people who have been through this process, innocent people who've had their lives destroyed by being put in prison on accusations which are totally unfounded, and they've spent months and sometimes even longer in prison before eventually, and this is only the ones whom the system itself proclaimed to be innocent at the end. And they've calculated that there have been 1,000 innocent victims of this system every year.
Well, thank you, Torquil, for speaking from Rome.
With the European arrest warrant.
Well, thank you for explaining how fundamental an issue the European arrest warrant is. It's one of those situations where it only affects a few thousand people. However, we need to have our minds focused, especially with us not appearing to get any Brexit whatsoever. Lots of British people will be travelling to the continent in the next few weeks. It's enough to focus the mind. They could be watching out for Brexiteers. We're the troublemakers. We want to come out of the EU, and there is nothing to stop them whatsoever in issuing a warrant, if they so wished, while we were abroad, back to the British courts.
Well, while we're abroad, they don't need to issue a European arrest
when we
warrant.
get
They
back,
can just arrest you on the spot.
yes.
And this has happened. This happened before the European arrest warrant. There were cases of British people. There was a case of a Scottish babysitter in Leghorn who, well, anyway, in the 1980s, I mean, there have been cases of British people and people of other countries too, who were arrested and unjustly imprisoned for a very long time before finally being found innocent. Now, I also wanted to say, if I may, something about the political implications. This is the European arrest warrant, you see, is a potential tool for tyranny, and it is being used in this way in at least two cases already, but they could be expanded and it could be used much, much more. There was a case of a Romanian, actually a German citizen, but of Romanian origin, called Alexander Adamescu, which has been researched by the Freedom Association, who have a lot of details on their website. And he was sought after by the Romanian authorities on trumped-up criminal charges, but the case is clearly political because his father had a newspaper in an opposition newspaper in Romania, and himself was imprisoned and died in prison, I think. And anyway, but there is now another case where it's openly being used for political persecution. And this is a very important case which the national media have talked about very, very little. The Scottish media have talked about it a bit more, but for another reason. This is the case of Professor Clara Ponsati, who is a Catalan professor who has a teaching post at St Andrews University in Scotland. It so happens that she was helping Puigdemont with his attempt at having a referendum to separate Catalonia from the rest of Spain. Now, the penalties for what they did under Spanish law are extremely harsh. And the Scots who sought independence from Britain should thank their lucky star that Scotland is attached to Britain and not to Spain. Because the British attitude to their demand for independence was, you want independence? Okay, have a referendum. The Spanish response to the Catalan demand was, first they sent in their riot police, the Spanish component of the Eurogendarmerie, the Guardia Civil, into Catalonia when they were having the referendum, and they beat up people, the pollsters, as they were trying to go to the polling stations to vote. They assaulted them physically, and, well, I mean, it's all been on video and television, and so people know about that. And then the people, like this totally harmless Professor Ponsati, has been accused by the Spaniards in their European arrest warrant of violent rebellion. I mean, it's ludicrous, but you see, the Scottish court, she's already had a preliminary appearance, and she's going to have another one, I think, on Thursday, 5th of July, in Edinburgh. She has been accused of violent rebellion, but the Scottish court is not allowed, under the European arrest warrant legislation, to ask, where is the
evidence?
Where is the proof? Where's the evidence that she was violent?
They just produce a document, don't they? And it just has to be completed.
They don't even need to produce a document. They just tick boxes.
Yep.
And they don't need to produce any documentary evidence or any evidence of any sort at all.
No.
They simply make an assertion that they accuse her of violent, or indeed they can say the hypothesis of the crime of violent insurrection, and a violent rebellion, they call it, and misappropriation of public funds, because the money spent by the Catalan local government to organise the referendum has been told it's a criminal offence to do that. So in England they said, or in Britain they said to the Scots, well, have a referendum. In Spain they say to the Catalan, you want independence? Okay, have 30 years in prison, because that is the penalty that she faces if she is extradited. And this is clearly shows how the European arrest warrant is a tool for tyranny, because the Scottish, what must the European extradition system must be changed so that we restore to British courts the power to demand to see the evidence against the suspect.
Absolutely. So the
This
message...
is it, because the foreign courts cannot be relied upon to do this, because their system, it's not that they don't do it because they're sloppy, which is what the Brits tend to think. It's not because they're slovenly in their application of their standards and principles. It's that their standards and principles are totally different to ours. Because in 1215 we had Magna Carta, which limited and constrained the power of the state over the individual. At that time, in 1215, in Rome, the Pope was setting up the Holy Inquisition, which deepened and extended the power of the authorities over the individual. And when the French Revolution came along, Napoleon, who soon took it over, did not reject the inquisitional system and adopt the English system. No, he adopted and adapted the inquisitional system from service of the church to service of the state. And the Corpus Juris project for a single system of criminal justice for the whole of Europe, including the British Isles, and I attended the seminar in Spain where it was unveiled in 1997, that adopts entirely the Napoleonic inquisitorial system and trashes our system completely. Trial by jury, habeas corpus, no double jeopardy, out.
Well,
and that is why it is so important to focus on this issue of the European arrest warrant, which is the first step towards corpus juris.
Well, thank you, Torquil, for talking to the people of Democracy 17-4. It's obvious to me, and I'm sure it's obvious to many people now, that there is no Brexit in the judicial department. So we send a message to the government. We need a return of our sovereignty. We need a Brexit, and we need a return to the common law in the UK. Thank you so much, Torquil.
Thank you.